Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com. The law offices of Rajiv S. Khanna, PC. We do this community conference call every 2 weeks on a Thursday, same time, same phone number, and we've been doing it for several decades. The details are on our forums.immigration.com. We also post all over our social media. When you logged in, you heard certain disclaimers. These calls are subject to those disclaimers. I'll start first with the frequently asked questions. And if there are any follow-up questions, no new questions, to those frequently asked questions, I'll then address them. After that, I'll start on the questions that have been posted and any follow-up questions on the posted questions. No new questions, please. After we have done with the posted questions, we will then start, if time permits, with new questions. Let me begin with the frequently asked questions. So, what happens if H-1B employer revokes a quota H-1B before October 1st? So, I've got my H-1B approval. It is now August. And before October 1st, when my H-1B kicks in, my employer revokes my H-1B. And the answer is, the usual consensus of opinion is that in such cases, you have lost your quota. So you are back in the quota. You have to go through the lottery again next year when you apply. I find this troublesome, but until it is reversed by courts or by USCIS itself, that seems to be the policy. So, what time frame does it take? This is what was asked of me. What time frame does it take for revocation? And the answer is, it does not really matter because the revocation is effective retroactively. So, for example, let's say the employer asks for revocation of the H-1B on August 5th, but the government acts on it in September or even October. They will make it effective August 5th. So the revocation attaches to the case retroactively. Okay? So there is no other way around it unless you take the government to court and argue that the approval itself takes you out of the lottery. You don't have to wait till October 1st. I think it's certainly worth a shot. If anybody has a follow-up question on this, press *1. No new questions, only follow-up. Sorry, press *5, not *1. Press *5 on your phone if you have a follow-up question on this. So we have a follow-up question from area code 917. 917, where are you calling from?
Hi, I'm calling from Arizona.
Yes, sir. Go ahead.
So I am on cap right now with the current employer.
Right.
And I don't have any more H-1B chances. So if they withdraw my application and USCIS revokes it,
right,
does that mean I have to pack my bags and leave the country?
Unless you go back to another course and get into curricular practical training, or the new employer is, or at least you are willing to file a lawsuit against the government that this is the incorrect interpretation of the law. I think chances of success are small that you would win such a lawsuit, but I haven't really researched this issue or studied it in detail. The good news is if you are living in Arizona and the H-1B was approved from that Arizona-California area, you will be in the 9th Circuit, which is California, Washington State, Arizona. These states, the rulings from these courts tend to be more liberal in favor of individuals and immigrants than other circuits. So the choices are pack your bags and leave, file a lawsuit, or go back to school and get CPT. Okay?
Okay. Just one last note. If I don't work for my current employer will I get like 60 or 90 days of unemployment that I can use and then wait without getting paychecks and then join employer B on October 1st?
And that part I do not understand. So 60 or 90 days. So you're asking, you are on gap OPT and you have an H1B approval. Is there a grace period to join the employer? Is that what you're asking?
Right.
When does your not your I guess your OPT has already expired, right? After April 1st?
My STEM OPT is expiring August 13.
August 13. So, yeah. So, you want to join the H1B employer after October 1st, not on October 1st?
I mean, the approval start date is October 1st, so I don't mind starting October 1st or any day after October 1st.
Okay. But the idea of cap is you can continue working while waiting for October 1st to arrive. You do not want to work between August and October. Is that what you're saying?
Yeah.
I do not know the answer to that question. So the question is, if I am on cap, can I take a month and a half off, or 2 months even, before I join on October 1st? You may want to check with your DSO, because I don't know if there is any rule on this. I'm pretty sure there isn't. But check with your DSO, see what they suggest. Because this is more a question about what can I do when my cap extension is pending. And a cap extension is simply an extension of your OPT. Therefore, who is the ultimate authority on the OPT issues? It's your DSO. Check with them. Okay?
Okay, thank you.
Good luck. Okay, let's go on to the next frequently asked question. So, can I take multiple jobs or work for multiple employers when I'm on my 485 EAD? So, Vineet says, can I do a second job on my GC EAD and continue working with the sponsoring employer on H1B? Well, first of all, you cannot have an H1B and an EAD together. The moment you start using your EAD, your H1B gets to go to sleep. And we have a lot more on this in our frequently asked questions on immigration.com. We've been discussing this topic on how the H1B goes to sleep and it can be awoken again. It's not a problem. And that doesn't void the H1B status, it puts it on a hiatus. And it's perfectly okay for you to do multiple jobs. The main issue here is that the job for whom you have filed the green card, whether directly or through supplement J as a second employer, you can, as long as you have the intention to remain there indefinitely, what you do on the side, whether you start your own business and do another job or do another job, I don't think it's relevant. I think you are okay to do that. *5 if you have a follow-up question. *5. So the key here is to have intention to continue working with the primary employer. Area code 614. There are a couple of questions. Area code 614, where are you calling from? 614. Hello?
Hello?
Yes, sir. Where are you calling from?
Hello?
Hanji, where are you calling from? Sorry?
From Ohio.
Ohio. Yes, sir.
Ohio?
Yes, sir. How can I help you?
So my question is, so if we go on to 485 EAD from the employer who has sponsored H1, then your H1B becomes void, right? So,
well,
being on EAD,
I don't want to.
Hang
on. It doesn't get void. It gets inactive. It can be reactivated. So keep going.
Okay. So if we switch to 485 EAD
Mm-hmm.
and then go for another full-time job,
Mm-hmm.
is that legally allowed?
Yeah, definitely. That's what I said. As long as you have the intention to remain indefinitely with the primary employer, what you do on the side in addition to that is your business. Okay.
Okay. Okay. Thank you.
You're welcome. Good luck. Area code 415. Where are you calling from? Area code 415.
California.
Yes, sir. Go ahead. You have a follow-up question?
Yes, sir. So the follow-up question is, as you mentioned, that once we get the EAD on pending 485, you can take another employment as long as you continue with your sponsoring employer. Now, is that a rule when you are on W-2? Is there a rule that you have to have a full-time work employment with the sponsoring employer, and then you can do any additional hours with a different employer?
That's a little difficult to answer because there are several components, several moving parts here. So the first moving part is, remember, green card job is a job in the future, right? So even if you are working less than full-time hours with the sponsoring employer right now, it's okay as long as they'll give you a full-time job soon after you get your green card approval. So that's the first moving part. Okay. Now, the second moving part is, normally what happens is government can ask for, I've never had them do it, but they can ask for an explanation that if you have a full-time job with this employer and you're already working with them part-time, why don't you not have a full-time job? Okay. So why are you waiting for the future to arrive? These issues can come up. They should be discussed with your lawyers. But none of this is beyond the realm of possibilities. Having a part-time and a full-time job, or a part-time and a part-time job, all of this is possible. Okay.
Okay.
What else?
Sir, can I ask another follow-up question to this?
Of course.
Sir, so if you get the EAD and the green card, maybe it's a few months down the line or maybe a year, do you have to work for the sponsoring employer to show the intent? Or you can wait until you get the green card?
Yeah, we've actually discussed this issue several times. So the idea here is this. When you filed the 485 or the I-140, depending upon how you intend to join the future employer, you have the intention to join them and work with them indefinitely. Once the I-140 is approved and the 485 has been pending 180 days, you actually never have to join them, because you can take advantage of EC21 portability and join a completely different employer, never having joined the sponsoring employer. But you've got to be able to, if called upon, show that you had the good faith intent to join them when you started your green card, filed your I-140 and filed your 485. At those 3-4 junctures, your intention is important, may be called into question, usually it is not, but you should be ready for that. So discuss with your lawyers, make sure you have considered all the variables before making this decision. Okay?
Okay, thank you, sir.
You're welcome. Yeah, I had a call with a client today. They are a medical practice, fairly large medical practice, 50 plus doctors, and one of their physicians and physician managers was asking, why can't we ever answer questions yes or no? And I laughed and I said, because there are no simple answers. There are so many variables. Immigration law is one of the most complicated areas of law in this country. So very difficult to answer yes or no to most questions. How long can you be unemployed on AOS EAD AP? This was from Wiki ATTX. He said, how long can I be unemployed on adjustment of status employment authorization? And the answer is, well, there is no rule on that. As long as you have a job at the end of your wait you should be given a green card. So let's take an example. Employer X sponsored your green card. You filed I-140, 485. I-140 got approved. 485 must be pending 180 days. Now you are free as a bird. You were not employed for 7 months or even a year. After a year, you got a job. Until the government sends you an RFE, you are not obliged to produce a job. Okay? So therefore, the answer is you can be unemployed as long as the government doesn't ask for proof of work, and you can produce work even if it is a future job offer. And it is not relevant for the USCIS that you have a pay stub for every month that you've been working. Don't worry about that. Any follow-up question on this? No new questions. Follow-up question, press star 5. Okay. Let's see if there's another frequently asked question. Yeah, there is. So it's kind of related to the earlier discussion. Can I take a long break after I get my green card? And the answer is yes, but the bottom line here is, let's say I get my green card August 1st. On that date, I should have the intention of continuing to work for that employer on an ongoing basis with no end in sight. If you have an end in sight, like I'm going to quit in 3 months or 6 months, it could be argued that this was not permanent intention. So if you have no intention to quit, but a week after you get your green card, let's say you win the lottery and you want to sit at home and enjoy your hookah while you watch cricket on the television, I think that's perfectly legitimate, because when you received your green card approval, on that date you had no intention of quitting, but rapidly thereafter the situation changed. So if the situation changes, I have no problem somebody quitting work and staying out of work for as long as needed. Star 5 if you have a follow-up question. So the important thing here is your intention, not so much as how long you've been without work. Now let's get started on the non-frequently asked questions. So the first one is, how can I bring my brother here? He's mentally challenged, 42 years old and unmarried. There is no particular visa for it, unfortunately. Sirisha, you can look at the option for a humanitarian parole. Sometimes that can work out, but usually there is no particular visa. There is also a procedure, and you can Google that, immigration private bill. Immigration private bill. How that works is, a member of the US Congress rises up and passes a special law for your brother. That's done all the time, believe it or not. But you have to be able to approach the local congressman's office and see how they feel about sponsoring your brother for a special bill. Bill is like a law. Okay. Star 5 if you have a follow-up question. And Sirisha, we can try for a humanitarian parole for you. You wanted me to tell you what we can do. We can try, but it's not something anybody can guarantee you. I would try also the private bill if I were you. Okay, doesn't look like there's a follow-up question on this. So what do I do when my EAD extension is pending? Of course, you cannot work. 485 EAD is different. Even while it is pending, you can continue working up to 180 days. Okay. Should I apply for leave without pay while we are waiting? You can do that. Can I simply take the paid leave which I accumulated? Definitely. Because see, when you are getting paid for work that you have already done or leave that you have already accumulated, you're not unauthorizedly employed because you're not employed. So it's perfectly okay to do that. My company is giving me option to go out of US, come back after 1 year with new visa. If my spouse is here on H1 and I want to visit US during 1 year, Do I need to come only on B1, B2? Can I come on H4? You have to have somebody look at the law very carefully. But from what I recall, if you visit, then you have to spend that many extra days outside USA to complete that 1 year that you need to reset your H1B clock. Double check that. I am not sure exactly what the law is, but there are some twists in that law. If I want to come on B1, B2, will consulate approve my visa as my spouse is on H1 and green card being processed? Nobody can answer that question. You can certainly try. As long as you don't make any misrepresentations to the government, there's no harm in trying. My spouse's client is offering full-time conversion. If she joins and the new employer's H1B is approved, will USCIS deny my pending H4 and EAD immediately, or will they wait? I think they'll wait for the employer A to revoke. So what we have been doing, I think it is incorrect practice and USCIS should change it. In these cases, we just file the H4 and the H4 EAD again. Okay. Star 5, if you have a follow-up question on this. Star 5. Okay. Area code 214, I think that's Texas. 214, where are you calling from? 214?
From Texas.
Yes, sir. How can I help you?
So, first thing you are telling for leave without, I am still India employee. So, and I have like 60 days leave pending with my employer.
Uh-huh.
So, you are telling I can avail that leave as long as I am not employed, but I am still employed. I am not quitting my job, but I can continue when my EAD comes. So, that suppose there is 30 days gap between my EAD expire and new EAD comes. So, in that way, I am still employed, but I'm not working for the client. I'm India employee.
Okay, I have absolutely no idea what we are talking about. Are you the person who posted this question?
Yes.
Okay. So you said I'm an India employee, I have 30-day grace period. None of that is coming together in my head.
No, what I'm telling, I came on L1A.
I understand. Right.
Now I'm on the H4 EAD.
Right.
If my H4 EAD is acting on September 30th,
right,
and my new EAD is coming in somewhere November, I have 1 month gap.
Right.
So during that 1 month, do I need to apply leave without pay, or I can use my accumulated leave without quitting job?
Okay, first of all, you are confusing employer's requirement with USCIS's requirement. USCIS doesn't care whether you take leave without pay or accumulated leave. They don't care. As long as you are not working during that time, that's all they care about. Rest all is between you and your employer.
Okay.
Whatever they prefer. You can as long as you're not working, you can be paid for leave you accumulated already. No problem.
Okay. So, but I need not quit my job, right? I did
not. No, sir. No, you do not. As long as you're not working, you can actually just stay at home, and even if they continue paying your benefits, for example, if they continue paying your medical and all, no problem. Because you're not working, you see. If you were working, we would have a problem.
Okay.
All right.
Okay. And this, I agree what you are telling. If I go outside and come back, say, for 4 weeks, I need to be additional 4 weeks outside to make.
Yeah, that's where I have always believed that to be the law. But recently I was reading some case somewhere which made me kind of reconsider, well, there is a little twist here. So the bottom line is, if you are here 4 days, you've got to be extra 4 days outside. But exactly how that works, I don't remember. Somebody should look at it. I can't tell you the definitive answer.
Yeah.
Okay.
USC's website says if you short visit on visit is okay for the travel, tourist.
Right.
For business or tourist visit, okay. So I was concerning if that is okay, but can I have to come only on the B1, B2 visa, or I can come on H4 visa as well?
I think there is no difference. Okay. I don't believe so. But whenever I deal with immigration law, I deal with it like I'm handling live snakes. I'm very careful. I double check everything. So, because laws will always surprise you. There are so many little nuances. My preliminary answer is there's no difference for this purpose between B1, B2 or H4. But let's have you double check that. Okay, let your lawyers take a look at it. All right?
Yeah. Their website says B1 short business visit
Yeah,
or
sir, I
tourism
understand.
visit.
I understand. But what I'm saying is I want it double checked. Okay?
Okay.
Good
So
luck.
if I go out and someone
Sir, I got to move on.
will you have to
I have to move on. Make your question really short. I can give you another couple of seconds.
Thank you so much.
Yeah. Okay, guys, I have a limited amount of time here. So please engage me with only the most important questions you have. Reentry permit process and COVID-19 vaccination. So from Arjun ji, I have taken my first COVID date. So there are some completely non-immigration, non-related questions here, which I don't really care to answer because they are a part of the CDC guidelines. Okay. I don't have to self-quarantine if I am fully vaccinated. That depends upon CDC. Will I be allowed to drive a rental car or take a cab? I do not know. CDC. FedEx the 131, once I confirm the application has reached USCIS, then travel back. You can certainly do that. The law is on the date you apply for your re-entry permit, you must be in the United States, which means the date the package is received by the USCIS. And then you have to come back for the biometrics. Will they consider my previous fingerprinting and use that? Sometimes they do and sometimes they don't. They had started doing that for H4 EADs. Will they do it for 131s? So far, we have not seen that happen. Star 5. If you have a follow-up question, Arjunji. Star 5. Okay, you're calling from India. Go ahead, please, Arjun.
Hello, Rajivji. This is Arjun from India.
Yes,
Thanks for your excellent service.
Yes, sir.
You answered almost all my questions. I just have one thing. I want to say one thing that I'm currently in India working for a US-based employer on actually in I-131.
Okay.
It just expired on June 21st,
Okay.
2021.
Okay.
I could not come before that because the second dose for India got extended to 3 months.
Right.
So I got my second dose and planning to travel to the US within a month.
Right.
I'm following CDC guidelines. I have to wait for 15 days after my second dose. And
Right.
So since my expiry date has expired, but I have valid documentation from Indian government saying that the second dose duration has been extended. So I'm hoping that with my documentation and from previous I-131 and my N-147 approved, they will allow me to enter to the US.
Yeah, I think so. I think so. Because, Arjun, one of the things that the government did was, even for people who did not have re-entry permits, and they'd been outside USA for more than a year, they said, as long as your green card has not expired, we are going to let you in. And they've let in a lot of people like that.
Okay, perfect. Thanks. Last question, I'll be very brief. So I just, before this call, I just saw the current timelines from the USCIS website. It says 19 months to 24 months.
Right.
I'm a little shocked with that.
Yeah.
So when I did this I-131 in 2019, I got a response within a month. I delayed by 1 or 2 months because of my meetings. Generally, it's a 1 month response for the biometric appointment. Now it says 19 months to 24 months.
Right.
So if that happens, I have to come to the US every 6 months? Or
no, I would say,
I can't even imagine the scenario.
Come within 1 year. If you can come every 6 months, great. But definitely don't be outside for a year. Less than a year is better until this is decided.
Okay.
Good luck.
Okay, I'll do that. Thank you so much. Your answer was very crisp.
You're welcome.
Thank you so much. You made my life better because I thought every 6 months.
Oh, absolutely.
1 year is a lot better.
I think so, Arjunji. Good luck, sir.
Thank you.
Bye. Okay. So the next question we have is question number 7. So EC21 regulations, COVID-19 layoff, lump sum severance. There's a lot here. Let's see. I have a question on EC21. EB2 India, July 2010. Worked for employer A for 15 plus years. Filed for 85. Then I filed for a change of employer. This could be May 20. I have the feeling this may be May 21, not May 2020. So I filed for change of employer H1B for employer B. I didn't join. Oh, that's okay. That's not a problem. Employer A filed 45J. Yeah, so if you filed an H1B and it was approved but you never changed, no problem at all. The H1B filing does not interrupt the flow of your H1B with the employer A. Jan 2021 terminated, got lump sum. Immediately joined employer B. So employer A has not withdrawn 140 or H1 more than 180 days. It looks like you are good. I don't see any problem. My intention was to continue working for employer A. Am I protected by EC21? I think you are protected, sir. Employer B's attorneys will not file 485J. They will respond to any RFE. What the heck? Just get yourself your own lawyer. See if your new employer will work with outside lawyers to furnish you a supplement J. Okay, I disagree with the lawyers that you have to have the intention of working with that employer for 180 days. It is the pendency. This is very clear. There is actually lawsuits on this. So in fact, we had a lawsuit filed for a client from Minnesota, and the government immediately approved the case when they had tried to deny, saying, well, he only stayed with the employer for 90 days and then he left. His 180 days were not over. And we said, that's not required. Pendency is required, not the intention or the actual remaining with that employer for 180 days. So I think you are covered by EC21. *5, if you have a follow-up question, press *5 on your phone, please. Okay. Maintaining H1B status while getting an MBA full-time. First, I'm on H1B, cap exempt, I want to get onto MBA. Am I allowed to do a full-time MBA being on an active H1B? Well, the policy says the H1B should be incidental, education should be incidental to the H1B. What does that mean? That you may not be able to go to school if you are converting to part-time H1B and going to school full-time, although I know somebody who, upon my advice, actually finished all of their law school, 3 years of their law school, on a part-time H1B and a full-time law school education. So the literal reading of the policy is that your school should be incidental to the H1B. The way I read it, if you want to be very strict about it, you should continue your H1B full-time. You can also go to school full-time. Can I take classes during COS from H1B to F1B? My answer is I believe yes. Why? Because the usual rule the government seems to have followed is this: if the status from which you are changing, which is H1B, allows you to study and you are converting to F1, you can continue going to school because H1B allows you to study. Am I allowed to work? Absolutely. Because until you actually get a change of status, you are still on H1B. *5, if you have a follow-up question on this, press *5. So, Katie says her employer's attorney lost the approval notice. Do I need the original approval notice to get my visa stamping, H1B visa stamping? And my answer is I do not believe so. But it is a good idea to send an email to the consulate and inform them of the facts. I think you should be able to go and get your stamping with just a photocopy, because they have an entire original copy in their database called PIMS. The PIMS database on the cloud has all your information. *5 if you have a follow-up question. Okay. Let's go on to, so this is a little bit more complicated. Downgrading EB2 to EB3 for husband and wife. What happens to CSPA, etc. So EB2 priority date is 2013, filed 485 along with downgrade to EB3 and my wife, for myself and my wife, but did not file for my daughter because I did not know when the PD will become current. I filed for her 539 change of status to F1. No progress. My priority date became current for my EB3. My I-140 downgrade is still pending. I'm planning to file for my daughter's 485. Absolutely do it. Okay. What happens to the I-539 now? See, there is no law that says you can't apply. In fact, I know many students who've done that. Even while their 485 was pending, they received their 539 approval. If you look at the language of the law, well, maybe not. But I think there is an unwritten policy that USCIS is accommodating these young people who are stuck in this weird situation, aged out, can't be on H4, green card pending, F1 is a problem. They are all getting F1s. And I would not abandon the 539 if I were you. Can we file for I-140 downgrade premium? And the answer is once you get the receipt, it's worth trying. So try. *5 if you have a follow-up question on this. *5. Area code 408, California. California, go ahead, please.
Yeah, hi, thanks. This is me. I posted this question. So if the F1 gets approved, then do I need to do anything subsequently or just
no.
Her 485 pending?
Let it stay pending.
We are good?
Let it stay pending. Nothing to do. Okay.
Okay, excellent. Thank you so much.
You're welcome, sir. Good luck. Yeah, this is an odd situation for parents to be in. Okay, so I believe the last question today is converting from H, and we'll get started with new questions after this. Converting from H4 EAD to H1B. I'm on H4, working on H4 EAD. I used to be on H1B 2014 to 2015. Can I go back to H1B without going through the lottery system? You know, it's difficult for me to say that because if you look at the language of the law, it says your H1 must have been approved within the last 6 years. So if we take 2015, so far you are still within 6 years. It's definitely worth a try. Okay, definitely worth a try. *5 if you have a follow-up question. *5. All right. Anyone who has any question, press *5. So we have 1, 2, 3, 4, 5, 6, 7, 8 questions. All right. We will take care of these. But no more, okay? Well, 10 questions. Wow. 10 different people raised their hands. All right. Well, I'm going to finish these questions. So whatever time it takes. Let's start with area code 415. Guys, please be mindful of the time and try to make your questions short. Area code 415, where are you calling from?
California, sir.
Go ahead, sir.
Sir, my question is about the I-693 medicals. So when the 485 was applied, the attorneys didn't file for the medicals, saying that because
we don't do that.
Was not correct.
We usually don't do that. Yeah.
So, sir, is it so right now? As I came to know that the USCIS is rushing to use the spillover visas, green cards. Is it advisable to send the 693
absolutely
to USCIS without that?
Absolutely, we are doing it. USCIS had previously said don't just bring them to the interview, but then they started waiving interviews. We are sending them in. What is the worst that can happen? The government will not use it. They will not be able to connect it. So big deal. You wouldn't have lost anything, but you would taken a chance at approval. So yes, go ahead. Okay.
So, sir, if we send it, do we need to take any particular step to send it, or like the address on the I-797 receipt should be used to send the?
I don't know the details, but I know we are doing it. Okay.
Okay. All right, sir. Thank you.
Good luck. Area code 916. Where are you calling from? Area code 916.
Hi, Rajivji. I'm calling from California.
Yes, sir. Go ahead.
Sir, I have an approved EB1A. I am a physical therapist, and with a pending 45. So I'm in the process of purchasing another physical therapy practice, and I am hoping to get an EAD soon. So is it advisable to purchase the practice, leave my current position with an EAD?
I would not want to comment on that. Well, no, actually, hang on one second. I have to actually look at your EB1A package. What you want to do is you want to set up a call or talk to your own lawyers who did the EB1A. Ask them, is my job same or similar? Well, actually, you're not doing, let me rephrase that, sorry. EB1As don't do EC21 portability. EB1As just have to continue working in their own area of expertise. So we have to look at your EB1A package to see what was represented as your area of practice. Was it research, physical therapy? So if the area of practice remains the same and you are going to continue in that area of whatever that area represented in EB1A was, there is no problem at all. So have it double checked. It's certainly possible. Okay.
Thank you, Dr. Rajivji.
You're welcome, sir. Area code 216. Where are you calling from? 216.
Hi, I am calling from Ohio.
Yes, sir.
My name is Pradeepan.
Yes, sir.
Good afternoon, sir.
Good afternoon.
Yeah. I have a question. A couple of weeks back, I have posted a question on your portal saying that my wife I-140 is recently denied.
Okay.
They have a denial reason like that. I will read the denial reason.
Okay.
They just put a denial reason as officer claims that evidence does not include the beneficiary will perform work from the address listed on labor certification, and the record does not establish that the petitioner have full-time permanent work for module leave.
Okay.
So we are, we have asked my wife's company to refile the I-140. So in this case,
hang on. Did they revoke the I-140? Did they revoke the 485?
It's not 485. It's I-140.
Okay.
We never filed on 485. This
Okay.
is I-140.
Okay. Yeah. There is a motion to reopen that can be filed, and that's what you should file.
So we can refile for this, right? So
yeah. You can also
specifically we can do it like.
Well, hang on. This is a difficult question to answer without knowing all the details. You can do a consultation with us, talk to your own lawyers. I have to look at the whole case before I can give you a decision. I'll take about half an hour. I can't really comment on this. I can tell you generically this.
Okay.
Whenever we have a situation like this, there are three options usually. I can file a lawsuit.
Okay.
I can file a motion to reopen or appeal, or I can refile the I-140. It all depends upon the circumstances of the case, what is more appropriate. That's all I can tell you right
Okay.
now.
So, okay. So we didn't go for the motion for appeal and the re-appeal. So because it will take more time, we have only 18 months left of H1B left. So we thought of going for a refiling. So is it advisable?
I don't know the answer to that. Again, you're asking me the same question without facts. I do not know. Okay. Good luck.
Okay, thank you.
You're welcome.
Yeah, thank you.
You're welcome. Area code 469. Where are you calling from? Oh, I'm sorry. Maybe I'm dealing with 612. 612? Say hello. I think I'm dealing with 612. Harish, 612. Hello. Okay, I'm going on to the next one, which is 469. 469. Hello.
Yeah, Rajivji, this is Shubham from Dallas.
Yes,
can
sir.
you hear me?
I can hear you. Yes.
Okay. Thank you. Thanks for holding this conference call. My question is related to H1B counselor processing route. I'm right now in STEM OPT EAD, and just 1 week back my H1B got picked. but I just don't want to go through the change of status route. I want to go through the consular processing route.
Absolutely.
Because I want to switch my job like really quickly. So my question is that if I go through the consular processing, is it true that when I visit India next, I am not required to get a stamp on my passport?
You're not
also,
required
like
to.
Another question.
You're not required to if you want to come back on your OPT. But whenever you want to start using your H1B, you have to go get a stamp or apply for a change of status again.
Okay, but it is mandatory if I go to the status change route, right?
Yeah, you have to. If you want to start using your H1B, you have only two options. Go get your visa stamping done or apply for change of status within US.
Okay, and just a small question related to that. If I break my this employer-employee relationship with this current employer, with before my case is approved, is it true that I will fall back by default to the OPT EAD, or because that's why I don't want to do the status change, which will be from 1st of October or 1st of November, because I want to keep my 120 days, if I need to search for another job. So
okay, I'm not sure I understand the question, but I can tell you this, because we are a little short of time. I have a lot of questions to answer. I can tell you this: if you are on OPT and you did not do a change of status, you are on OPT until the OPT expires. So there's no issue with that. Okay? Does that help?
Okay. Thank you. Thank you so much, Rajiv.
You're welcome. Good luck.
Yeah, it does.
Good. Area code 224. Go ahead, please. 224. Where are you calling from?
I'm calling from Illinois. Hi, Rajiv.
Hello, sir.
Can you hear me?
I can hear you fine. Go ahead.
Oh, great. So I have a hypothetical question. Basically, this is about working with two employers at the same time in the process of transferring, right?
Okay.
So, so basically, if I transfer to
okay, hang on. Let me get your. Hang on. Let me preempt your question.
Okay, sure.
I've dealt with these fact patterns before. You are on H1B, right?
Yes, I'm on H1B.
Okay. So you applied for an H1B, let's say on 15th August. Your H1B got approved on 20th of August. Now you have started working for the new employer, but you have some project to finish with the old employer. Can you do both jobs at the same time?
Right.
Can you do both? That's your question, right?
Yes, that's the question.
Okay.
And for how long I can do?
And the answer is no, you can. The answer is no, you cannot. Okay. You can tag team. Interestingly, you could work 1 week at the old employer, 1 week at the new employer, just not together at the same time.
Oh, I see.
Okay.
What happens though when we say we cannot? What is the implication?
Well, that's a violation of your status. That's a violation of your status, and you could be asked to go outside USA for visa stamping to get your status corrected. Okay.
Got it. Okay. Thanks so much.
You're welcome. You're welcome. Mm-hmm. Area code 281. Where are you calling from? 281. Area code 281. Okay.
Am I audible?
Yes, sir, you are.
Okay. Thanks, Rajiv, for this time. My question is, this is my I-94 expired in June 2017. The extension was filed in April 2017.
Okay.
Now, due to medical reasons, I had to travel to India twice in the same year, which is January and then in October 2017.
Okay.
When I traveled to India in October 2017, the extension was still in place.
Right.
But due to medical reasons, I still had to stay for more than a month.
Okay, hang on.
My employer and the client
hang on. What is this extension of? What were you extending?
H1.
Okay, all right. So you stayed for a month.
Yeah.
Then what happened?
Yes. So I stayed in India for a month, but then the RFE was there in November 2017.
Okay.
At that time, the RFE was not responded. I'm still in India at that time because
I had to complete the rights and all.
Okay.
So I could not travel.
Okay.
The employer did not respond to the RFP,
Okay.
and eventually the H1 was denied in 2018. So my question is that when the petition was still in pending status, I was in India. Did I get into any out of status or yeah?
Oh no, you have no problem, because when the case was pending, let me rephrase that. All the time you were in the US, you either had an H1 or your case was pending. So zero problem.
All right. Okay. Yeah. Then the follow-up question is that after that I got an employer who has filed H1, and the H1 actually got approved in 3 days. Within the approval notice, everything seems to be fine. Nothing there. But in the receipt notice, there is something which the code said you. Okay, so I talked with my attorney. They said nothing to worry. But I just want to confirm with
I have
you
no
that,
idea. I have no idea what that means. Sorry. No clue.
Okay.
All right.
Okay.
Good luck.
But as far as the situation, I have not got into any out of status.
No, I already answered that question. Please don't repeat. Good luck.
Okay. All right. Thanks.
You're
Thanks,
welcome.
Rajiv. Thanks
You're
for
welcome.
your time.
Area code 480. Where are you calling from? Area code 480.
Yeah, so thank you, Rajiv, for all these services. I'm calling from Arizona.
Yes, sir.
This question is for my brother case. His H1 extension got denied a couple of times back in 2018 and 2019.
Okay.
With the same reason, right to control and specialty occupation category.
Okay.
And he works in a MNC company, reputed MNC company. And the company is ready to do refiling again.
Good.
He's right now in India.
Right.
So will that be any issue?
No.
Or
No.
any other evidence that we have to provide?
No.
Apart from what we provide?
I never worry about prior denials unless there is some fraud or misrepresentation. Things like, employer-employee relationship or third-party control. These are all very overcomable issues. This is not something that's going to be a permanent problem. So don't worry about that. Okay.
Yeah, the evidence that we responded with education, job duty alignment, and client letter, JD, itinerary,
See, I don't want to. That's unnecessary information. All I can tell you is, from a broad overview, it's not a problem. What else?
Okay, got it. Okay, thanks.
Good luck.
I have one quick question regarding my dependent travel.
Right. Go ahead.
Yeah. So, my dependent visa is expiring in September this year, September 4th.
Okay.
And I got the new extension expiring in next year, March. They are planning to travel on 26th August.
Right.
So they have hardly 6 to 5 days of time to cross the port of entry.
Right.
So will that be any issue at the port of entry for enter into US?
Well, so your question is this, if I understand it correctly, the H4 is expiring within 3-4 days after they enter, correct?
Not before. Their expiration is September 4th, and they are planning to travel US 26th August.
So when they come,
before expiring
when they come back, when are they coming back?
They are traveling on August 26th.
When are they coming back, sir?
Yeah, they are right now in India. So
they are coming back into the United States. Yeah, I don't think that's a problem at all. Okay.
Oh, okay, got it.
Yeah, if your visa, if your visa is valid even for 1 more days, technically you are allowed to enter.
Oh, okay.
Okay.
Okay, got it. That's a great answer. Thanks. Thank you so much.
Good luck. Good luck, sir. Somebody calling from India. Go ahead, please.
Hello.
Thank you, Rajiv. This is Adam. I am actually a B1, B2 holder, and I want to travel to the US for a business visa, for business purposes. I wrote to the US embassy, and they basically denied my NIE exception. And I read online that I can travel to via countries like Mexico, stay there for 14 days, and then enter United States. Is that something that you've seen to work, or would I even require a prior approval from the US embassy, even though I'm transiting through a country like Mexico for 14 days?
No. The only thing you have to be careful about is that you are not going to a country where there are some other restrictions. So, for example, if you took a 2-week break in London, you still will not be able to travel because England has its own restrictions. So, but if you went to a country against which USA has no travel restrictions, you can stay there 2 weeks and come into the United States. No questions asked. Okay.
Just a follow-up question, Rajiv, if you have some more time.
Go ahead.
So just in case I take this route, I spend 14 days in Mexico and then try to enter the United States, and hypothetically speaking, the immigration officer denies my entry, it will not be considered deportation, right? They will deny my
No. There is no deportation at the border. There's something called I'm sorry, the word is they used to use the word exclusion. Now they use the word inadmissibility. So if you are found inadmissible, you can't come back for 5 years. But they do that only if they find something really hinky with your application. Usually if they are not going to let you enter, they let you withdraw your application. That has zero impact on your case. Okay,
so I then can just take a flight from US back to India.
Yes, sir.
And nothing is going to impact me negatively.
It should not. No, sir. Okay.
Thank you. Thanks a lot, Rajiv. Very helpful.
You're welcome. Good luck. Last question of the day is, there is one more after that, guys. Please don't do that.
Hello, sir?
Yeah, one second. Yeah, there's 2 more. My God, I don't know. I've answered far more than 10 questions, but okay. Let's keep going. Keep it short, guys. Keep it quick. I've got just about a few minutes more. Go ahead. Yes, sir. Go ahead. What is your question?
My name is Bobby. I'm calling from UK. I have my own business here. Because of COVID, I lost my contract. So at the moment, I'm looking for moving to US on an E2 visa, sir. So I need your inputs, if I can take my family together, can we both, myself and my wife, apply for work authorization along with the E2?
The way E2 works is, the E2 primary will get their E2 and the E2 derivative will get their employment authorization. Yes, it can be done.
Here itself, can I apply both from UK itself, sir, at the same time?
No. You can only apply for E2 from UK.
Just for the main applicant, that's all.
And you will apply for the main applicant. The family will get their E2 derivative visas, but they can apply for EAD only once they are here in the United States.
Okay. Sir, another follow-up question, sir, on this one. Suppose if my consulting is going on well on E2 visa, will I be able to? I just want to know what will be the process for immigration and.
No, that's not something I can cover in 2 minutes. Bottom line is, we have plenty of E2s who have, based upon their ongoing reinvestment into their business, they have done EB5s. When their investment became high enough. Okay.
EB5, sir, is it?
Yes, sir. Investment-based visa. Okay. Good luck.
Okay, sir. Yeah, thank you very much for your time.
You're welcome. Bye-bye. Area code 612. I think we lost touch before. 612, go ahead, please.
Yeah, hi. Can you hear me?
Yes, sir. Where are you calling from?
calling from Massachusetts.
Okay.
I became a U.S. citizen and applied for my parents' green card.
Okay.
I have got an RFE for the form I-864.
Okay.
I think there is some confusion about my tax return, which is filed jointly versus I-864. So need your suggestion, because the RFE says your joint sponsor need to file I-864. Then the second point says joint sponsor need to file I-864A. And the third point says I need to provide all the documents.
Okay, hang on.
I will do.
Hang on. Do you have a joint sponsor, or is it just you filing?
I can do either of them. So I can do a joint sponsor as well. So can you guide me what should be the process?
So normally, I don't know your case, but I can tell you this. Having a joint sponsor is a lot easier than trying to fight on the small details of your own tax returns.
Okay.
Okay.
And both of us need to file separate I-864?
That I do not know. My team takes care of all those details. But I know that whenever we have a situation like this, I'm the strategy guy. I'm not the forms guy. I always tell them, just let's bring in a joint sponsor if that's not a problem. Okay. The logistics and all, you can figure out from the form instructions. All right.
Okay. Sure.
Good luck, sir.
Okay. Thank you.
You're welcome. Bye-bye. All right, folks, we did that well. We are finished with the questions today. I'll see you again in 2 weeks. Thank you all for being here. It's always fun to talk to you guys. Bye-bye.